The Supreme Court recently highlighted a core problem in India's justice system. The lower judiciary suffers from stagnation due to prolonged litigation and massive pendency. According to the National Judicial Data, district courts alone carry more than 4.69 crore pending cases. Another Supreme Court bench even directed Delhi judges to undergo training because many lacked basic legal understanding. These observations underline systemic weaknesses at the subordinate judicial level. In district courts, a significant amount of judicial time is wasted on clerical tasks. Procedures under the Code of Civil Procedure require judges to call suits, issue summons, receive vakalatnamas and take appearances every morning. This consumes time from 10:30 a.m. until noon in most courts, leaving little opportunity for meaningful hearings or judgment writing. A proposed solution is to appoint a judicial officer or the lowest rank in each district exclusively to handle such ministerial work, issuing summons, recording ex parte evidence, receiving written statements and preparing next-day cause lists. By freeing senior civil judges and district munsifs from administrative burdens, courts could focus on trials and arguments throughout the day. A major source of stagnation is the declining quality of judicial appointments. Earlier judges were inducted from the bar with 10 or more years of practice under seasoned lawyers. Now, many newly recruited judges lack courtroom experience and struggle with disposal. Mandatory training with high court benches for a few months could expose them to higher judicial standards, effective hearings, and judgment writing practices. Procedural laws and new statutes have also unintentionally worsened pendency. The Commercial Courts Act mandates pre-suit mediation under Section 12. Even though parties in commercial disputes typically exhaust negotiations before approaching court, mandatory mediation often delays rather than expedites justice. Similarly, the 6-month cooling-off period for mutual consent divorce forces couples to remain stuck in litigation even when both sides are ready to separate. Confusion created by the new Rent Act, especially regarding oral leases and jurisdiction, has added another layer of delay. The Code of Civil Procedure itself contains outdated and overly technical provisions. Concepts such as separate preliminary and final decrees in partition suits and 106 rules under Order 2-1 for execution enable litigants to delay proceedings for years. Even amendments such as the 90-day limit for filing written statements have achieved little in speeding up trials. Pendency will not reduce unless obsolete procedural laws are revisited, competent lawyers are recruited as judges, and the subordinate judiciary is relieved of clerical responsibilities. What India's justice system needs most is timely termination of proceedings, not just faster initiation.